Blog Talk Radio.
Hello, everyone in the franchise world. My name is Paul Segreto, and this is Franchise Today. Today we're in week 5 of our 3rd annual franchise legal series on Franchise Today, and it certainly has been very, very informative, full of a lot of facts. Some eye-opening comments have been made with respect to different things in the legal world and how it relates to franchising. And if you haven't already done so, I recommend listening to the first 4 segments, which, of course, are available on demand on Franchise Today, and that'll be at blogtalkradio.com/Franchise Today Show. Today, as always, I'm joined by my co-producer, Joe Caruso, who's done a fabulous job putting together all the shows in this legal series, as he did in the first 2 legal series and other segments of Franchise Today, helping put together a very strong lineup of some of the brightest minds in franchising. Joe, how are you today?
Fantastic, Paul, and that was a very nice introduction. I appreciate it, and Franchise Today show is an important part of what you and I do together, and the reactions from folks in the franchising community are always very, very complimentary, and it's amazing how people are using the information and the knowledge to increase their education and people within their franchise organizations. So it's a great pleasure to be part of Franchise Today.
Well, it's certainly a great pleasure working with you on this. It certainly is a labor of love, but also it is very informative. Nothing to me is more flattering when I hear from franchisors week in and week out saying they're using a lot of the information from Franchise Today about best practices in their own internal training with staff and executives alike. I know last week we had Warren Lee Lewis from Ackerman Centerfeet talking about franchise sales best practices and of course, FPRs. And that, to me, was just the cornerstone of the entire legal series as it is each year. And if anybody has not listened to the show yet or hasn't already done so, make sure you send in your information, send Warren an email for your free autographed copy of the Franchise Seller's Handbook. It's a great desk guide that will keep you out of trouble and have you sell franchises the legitimate legal way. And again, if you don't listen to the show but you're listening to this one, just go to the Franchise Today Facebook page. That's facebook.com/Franchise Today Show, and you'll be able to access a link there as well, and we'll get you a copy of the Franchise Seller's Handbook. Joe, kind of give us a recap of the first few shows in this series and tell us what to expect in the upcoming weeks.
Well, we've had some unbelievably great guests, and these folks who weren't already personal and professional friends of yours and mine have been terrific. I mean, we had Lane Fisher leading off with private equity and franchising and due diligence, and followed by a great show on social media and technology with Lee Play, a Plave Cook. And then we did sales vigilance and leveraging franchise sales outsourcing with Mark Kirsch, also of Plave Cook. And then, of course, you were mentioning Warren Lewis, who's a dear friend, and I work with him on with the Capital Area Franchise Association, where I'm president. But Warren is truly the brains behind that because he's the founder, and he's kept that group together for over 20 years. And his show was extremely compelling because I think one of the most important takeaways from that show was, his characterization and commentary on how to create a culture of compliance within your franchise organization. And everything he said on the show, along with what he's written and codified in the Franchise Seller's Handbook, that's really the path to be able to do it. And Warren has been so generous to be able to make that book available to our audience, and it's a beautiful size. It is a desk reference, and I encourage everybody to follow your instructions and get a copy of Warren's book. And, of course, we've got a great guest today, Ken Prine, first-time guest on our show, and he's with Redgrave LLP, and Jonathan Redgrave, founder of that firm, has been a previous guest on the show. Next week, we've got an interesting show lined up, a little different perspective, but a very important one, dynamics of winning franchisee-franchisor relationships with Michael Webster. Michael's a Toronto-based franchise attorney, and he's also the strategic chair of the International Association of Franchisees and Dealers. And Michael's done some great work in improving relationships between franchisors and franchisees, and the interdependency of good systems and communications, along with supply chain, logistics, and co-ops. He's just a terrific franchising professional, and he'll be on next week. And then we'll be finishing up the series with a recap of the 2012 IFA Legal Symposium. You know, what do franchise lawyers talk about? And we've got Ursa Jackson, who's is instrumental in putting together the IFA Legal Symposium, and she'll be our final guest and bring us through the conclusion of this year's series.
Yeah, and it definitely is a action-packed series for sure. You know, I wanted to touch base a little bit on the International Association of Franchisees and Dealers and Michael Webster. This will be the third year that Michael is on the legal series. It really provides a great perspective. I know Michael is very active within the various LinkedIn groups. And, hey, Joe, you've been working along with Michael on some things with the IAFD as well. Give us just a little bit of kind of a snapshot into the IAFD and what it does.
Well, the IAFD is really about improving trade within franchise organizations between suppliers, franchisors, independent franchise associations, franchise advisory councils, and delivering better value to the franchise system. And that better value could be in systems and procedures and supply chain for franchisees that helps make those franchisees more profitable. It adds more value to that particular system and their business model because it makes them more competitive against their peers, whether the peers are franchise, chain operated, or independent. And the key partners on there are some of the best people in franchising. Some of the key partners that are part of the IAFD have also been guests on our radio show. And the content is on the IAFD in terms of what these key partners write and talk about is all original content. It's not aggregated from other sources. I mean, we all get different kinds of news feeds that are aggregations of things that pop up over the Internet and they get collected. This stuff is primarily information that is written for the IAFD platform, for franchising, and the nice thing is you can actually contact these authors. You can also comment on the site about what they're talking about. There's a great story on the IAFD website that came out, I think, yesterday or today. Yesterday it was. An attorney in New York, Tom Pitkoff, was writing about the International Franchise Expo that's coming, and one of the issues that was a major issue for franchisors exhibiting in New York in terms of compliance with New York because of the way that their registration rule works on first personal meetings and being registered with that state in order to be able to offer franchises for sale. And he's really he's an expert in this area. He's investigated the exemption process for the show so that franchisors who are not currently registered will be exempt from registration just for those 3 days. It's an unbelievably well-written article. He brings up some very interesting points, and he really brings it home with that maybe it's time that New York update its registration rules to make it more attractive for franchisors to be able to market there, much in the same way California has done, because California has a similar type expo. They're also a registration state, but there's not a complication that occurs because of the bureaucracy of the type of registration that New York has that California does not. So I encourage everybody to read that article. It's a fantastic article, and it really, for franchisors, it really talks about some things you maybe haven't considered. Franchise attorneys for franchisors have been reading it and giving some good commentary back on it. So I hope that helps give an idea of what the IAFD, International Association of Franchisees and Dealers, is really about. It's about improving business for all these different trading partners. And if you think about it from a trading partner perspective, franchisor, franchisee, service providers, suppliers, that's really about bringing those people together.
Well, certainly well said, and certainly to your point about the article yesterday about the New York exemption. In general, the states do need to do more to make it more business friendly as we try to pull out of this down economy. So certainly everything that can be done in that regard certainly is well warranted. And as you mentioned, our guest this morning on Franchise Today, again in the fifth segment of our third annual Franchise Legal Series, is Ken Prine, and Ken is the partner at the law firm of Redgrave LLP. He has represented regional, national, and international corporate clients in litigation in federal and state courts across the country. His emphasis has been on pretrial negotiations and investigation, discovery and motion practice in a variety of substantive areas of the law, including products liability defense, copyright and trademark law, affirmative action compliance, and general commercial litigation. Ken's particular focus for the past several years has been on electronic discovery, electronic records management, and electronic litigation preparedness. Ken, welcome to Franchise Today.
Thank you, Paul. It's a pleasure to be on Franchise Today with you and Joe.
Well, we certainly look forward to today's discussion.
Ken, this is Joe. Before we get into the topic of litigation and technology and franchising, it's complicated. I think we all know that litigation is complicated generally, but certainly in this digital age that we live in, it's becoming even more so. Maybe you could explain for our audience what makes Redgrave LLP unique in terms of its focus on information law and e-discovery or electronic discovery. And for the purpose of our conversation today, we'll be calling this e-discovery. But maybe you could give us kind of a view on what you guys are all about.
Certainly, Joe. There really are a couple of things that make Redgrave unique as a law firm in this space. One is we're one of relatively few firms that this is all that we do. We are an information law firm. We don't do a lot of other types of work. We don't do the merits work of patent cases or commercial litigation, although our attorneys come from a commercial litigation background in a variety of different subject matter areas so that we have an understanding of what our clients are dealing with in the litigation arena. But our focus, where we really drill down, is how do companies manage and produce and protect their information, documents, data. The other aspect, I think, of what makes us somewhat unique is we're a firm that's made up of both attorneys and technical experts. So we have our senior advisors, our analysts are not necessarily attorneys, although a couple of them also are attorneys, but who bring to our firm and the work that we do for our clients a deeper technical expertise. Many of them come from programming backgrounds, system analyst backgrounds, and from various consulting firms on the technical side. So we really are able to bring that comprehensive view of the legal aspect and the technical aspects of information bring those to bear on behalf of our clients to their information law, and specifically, as we're talking today, their litigation issues?
Certainly, Ken, litigation and franchising has always been a consuming, if not distracting, proposition, and typically something that both franchisors and franchisees like to avoid, and certainly should try to avoid. However, with the dominance of electronic communications, use of websites, landing pages, proliferation of social media, blogging, and social networking, it seems as though when faced with a lawsuit, a request for records production would be, unbelievably daunting and certainly complicated. So how has discovery changed, and what does it look like today in this digital world?
Well, that's a great question, Paul. Discovery at the core, in terms of the philosophy, really hasn't changed. The whole notion of discovery is still to produce to the other side those documents and information that are relevant to the claims and defenses in the case. But like you're correct in pointing out, the ways that we generate these documents and information are much more complicated, much less controllable now. Back in the day, there were paper files, and we went to paper files, and you looked through paper files and boxes and those type of records to find the information that was responsive to various discovery requests. Now, there are a lot more places to look. And while it is daunting in that respect and complicated, I think both franchisees and franchisors, when faced with litigation, can take if they can take a step back and say, what is it that we're really looking for, and then ask the question, where are we most likely to find what we're looking for and what we need to produce to the other side, it may help to cut through some of the noise of all the different sources and places where information can be found.
Certainly it seems like when looking at this from a litigation standpoint is not a lot different than how I start out on the marketing side using social media and other type of digital processes, being cross-platform, multi-tiered, because today's day and age, things are no longer linear. They're no longer step by step by step. There's so many different collateral type of areas to touch into and look at, like you said, look at where this might be and how to pull it back in. One of there was a story on the news several weeks back right in my neighborhood. A matter of fact, it occurred a couple of 100 feet away from a former business that I owned here in the Woodlands, Texas. And it's all over national news where this woman confronted this new mom coming out of the doctor's office with a 3-day-old and basically, kidnapped the kid and wound up shooting the mom. And it was really a horrific story. But what's been transpiring in the news since then is investigators looking into determining ahead of time, understanding ahead of time that this lady's defense attorney is probably going to have a plea of insanity. And the investigators are already looking at her social media activity, specifically on Facebook, leading up to the event, that shows that this was kind of a premeditated process, step by step, that was leading up to the actual abduction. And it's interesting how social media is fitting into all this, and certainly social networking and technological innovation, it's not slowing. So how might these advances impact litigation and discovery?
A lot of businesses are asking this same question as they're trying to keep pace with the technological innovations and even different ways of working. A number of our clients are looking at the question of when people want to bring their own personal device, do you allow access to the network? And if you even have a policy that says, well, we want people to use their own devices to do their work, that's a question that we weren't even asking really 10 years ago, and certainly didn't even occur to anybody 20 years ago, because if you remember what computers were like 20 years ago, you weren't going to carry it around with you. But as technology continues to change, discovery and litigation is going to keep up. But one of the things that we've seen in these advances of technology where our clients have dealt with this effectively is in working on the integrating into the process of introducing new technology, whether it's new social networking type of technologies or new systems within their businesses, is to ask the question up front as these systems are being rolled out, as people are developing policies, if this system, if this technology becomes subject to litigation in the future, how will we handle that? How will we be able to preserve the information that is in this system, or how will we be able to access? What information are we going to monitor in terms of like some of your social networking sites? What are we going to be watching for? And so to bake into the process of introducing and using new technology the question of if this is subject to litigation in the future, how will we handle it, really helps. We're seeing it help our clients get ahead of the question so that the first time they're asking that question is not when a lawsuit comes and lands on the desk of the general counsel or the president of the company.
Yeah, very, very interesting indeed. Looking at this, and I imagine you really have to look at it from a business perspective, too, on the outside looking in, and try to anticipate or project out, where could they possibly have run with certain things in order to cast that wide net out, whether it be, something on YouTube, something on SlideShare, and then, of course, into the common social media such as, Twitter and Facebook. And, people are using social technology in so many different ways, and getting down to the specifics regarding technology and workflow automation, certainly they've made individuals and companies definitely more productive. However, it also seems to have an unintended consequence of creating that document management nightmare, especially for franchisors, franchisees, and of course businesses in general. Back in, as Joe refers to, the horse and buggy days of paper, when one completed a transaction, the file pretty much was the record. And if you lost it, it was truly lost. But now, virtually, pardon the pun, nothing is truly lost. So what's a business owner to do in the event there's actual or anticipated litigation and they receive a hold notification from the other party's attorney?
There are a couple of things initially that the business owner should do. One is to realize that even if you receive a hold notice or a hold notification or a hold preservation demand from the other party's attorney, the business owner, you don't have to satisfy the other party's attorney. You're really working to satisfy an audience of one, and that is the judge. So just because another party's attorney says you need to preserve all of these different categories of information doesn't necessarily mean that that's what the business owner needs to do. Certainly the business owner should look and say, okay, this is a roadmap to what may be of interest to the other side. And there is definitely a preservation obligation once litigation is either pending, once you've been sued, or reasonably anticipated. And the whole notion of reasonable anticipation of litigation is one that it's sort of the notion of a trigger. What constitutes a trigger? When do you cross the line from I think I might be sued to I'm pretty sure I'm going to now I have been? And so there's a continuum. There are a lot of factors that courts will look at, unfortunately, usually in hindsight. But when you have a pretty good sense as a defendant that you're going to be sued, then you want to, as a business owner, take a look and say, okay, how do I preserve the information that may be related to the claims that are being made in the case or my defenses that I'm going to make in the case? And there, again, the place to begin is to know your information. What information do you have? What paper information do you have? What electronic information do you have within your office, within your own computer system? What electronic information do you have an awareness of that is outside? Because a question that often comes up, that we get often from our clients is, I anticipate litigation or I've been sued. There's information that is within our, we call it possession, custody, and control. It is the company's information that the company controls. The preservation obligation clearly attaches to that. But then the question is, well, does it attach to things that are not within our possession, custody, and control, things that other people have, third parties? Do we need to notify them? And in some cases, maybe you do. Maybe you need to reach out to a third-party vendor who manages some of your information or someone else you know who has relevant information and give them notice that says, we've been sued, this is the issue or these are the issues. Please preserve documents and information that relate to these issues. And certainly,
hey, Ken,
yeah.
Go ahead, finish your thought, and then I'll ask my question.
Well, all I was going to say is that, certainly a business owners, with respect to preservation, you want to think slightly overbroad. The place to be narrow is at collection and production. The place, if you're going to be overbroad, the place to do that is preservation.
Ken, it strikes me that there ought to be some tried and true practical steps that business people can take and companies can take in the preservation of information, through document retention policies and procedures. But, how do you make that stick, and how do you create a routine within your company, not because you're anticipating that you're going to get sued at some point, just because it's a good practice and this is how you should do things in this digital age?
Great question, and I think there are really two parts to the answer. One is, what do you do proactively in your general management of your company's information? And second, what kind of a playbook or checklist can you have in place in the event that you're subject to litigation and you get involved in litigation, so that you don't have to make it up and start the process at the point that you're being sued, which for anybody who has been, even if you're a larger business owner, it's an emotional time in some ways and not the best time to be making these sort of policy and procedure decisions. So the first part of, how does a company practically manage your information? Why would you retain anything, whether it's paper or electronic? You keep things either because there's a business reason to keep them, you need them for the operation of the business, or because there's some kind of a legal or regulatory reason to keep them. And if you're not keeping information for one of those two reasons, then I pose the question, say, why are you keeping it? If people like to, pack rat things, or in case I might need to look at this at some point, that's a business decision. But to have an overarching information governance or records management approach that says, as a company, as a franchisor, as a franchisee, and really any business, we're only going to retain the information within our business that we need for our ongoing business purposes or to satisfy some kind of legal or regulatory obligation. And frankly, one of the things we're seeing with a lot of our clients now is they're looking at stockpiles of information that have been saved for years or decades for no particular purpose. And they're looking around and saying, why are we keeping this, and how can we legally defensibly get rid of the things that we no longer need? And there's a tremendous freedom that comes from that. There's a freedom in storage space. There's a freedom in saving time of people people within the business looking for information. At the recent MER conference, Managing Electronic Records in Chicago, one of the presenters was saying a study was recently finished up that showed that employees typically spend about 20 to 25% of their time looking for information. And part of that is because there's this proliferation of information out there. So the first part, how do you get a practical solution of how to get your arms around preservation? Only keep what you need to keep for business or legal and regulatory purposes. Second is put a process in place, a simple checklist that says if we're sued, these are the things that need to happen. Number one, we need to alert our IT department. If you're an organization that's big enough to have an IT department, alert our IT department that we have a piece of litigation. Tell them here's what it involves, and ask them what systems, which of our information systems that hold our documents and information, contain information that might touch on these issues. Maybe it's financial records. Maybe it is human resource or employee files, HR records. Whatever the subject matter is of the lawsuit, to say what systems, and then to instruct those IT people, please take whatever steps you need to take to make sure that our systems don't automatically purge information out of that system until we've dealt with this litigation issue. And then who are the people? Identify who are the key people in the organization who will have information or who are most likely to have information that's related to this piece of litigation. And sit down with those folks and say, and maybe this is the point where you have your outside counsel who you've engaged for the matter who also sits down, because they'll want to find out the factual background and the subject matter of this. But ask people, when you were dealing with this transaction, this employee, this person, this situation, the subject matter of the lawsuit, where would you keep information about this? Where would you file it on the network? Did you have an email folder where you kept things? So that you can get your arms around where is the information, because once you know where it is, preserving it is relatively straightforward. And probably your third step there is to make sure that the individuals within your organization who are most likely to have information have a written legal hold notice or preservation notice. And it can be as simple as saying, we've been sued about these issues. If you have information about these issues, do not delete or modify that information. And that's
our guest this morning on Franchise Today is Ken Prine, partner at the law firm of Redgrave LLP, and we're talking litigation and technology and franchising. It's complicated and really some interesting information, and we highly recommend, holding on to this segment of Franchise Today on demand, sharing it with others within your organization. It's really some valuable information. Joe, I think you had another question for Ken.
Yeah, Ken, you've mentioned some practical steps. I'm also kind of wondering, and I don't want to sound redundant, but are there strategies for reducing the burden of collection? And what do you suggest in that particular area? I mean, that's a little bit different than the preventative things. But what's the process? What does not a franchisor, but a business owner, franchisee generally do in order to make that burden of collection less arduous and more efficient?
Okay, great question. And this is really where a lot of business owners are interested, because this is where you start being able to manage the cost of the discovery phase of your litigation. And if you could almost envision a funnel with respect to your information, preservation is the biggest part of the funnel, and then as the funnel comes down, you have collection and some kind of processing for relevance, and then some kind of review of the information. Again, and not to be redundant, but the best way to reduce the burden of collection is to narrow the top of that funnel, and for a company to have preserved or kept around and available only that information that they need for business or legal regulatory purposes. Beyond that, when you get to reducing specifically the burden of collection, so you preserved a certain amount of information, and now you're saying out of this, stockpile of information that we've preserved, what do we need to collect? A couple of practical steps that the business owners can take is to try to narrow the scope of what is relevant to the lawsuit. And in working with outside merits counsel to be able to narrow that through early motion practice or through negotiation or discussion with the other side, some of those kind of legal strategies to try to narrow the scope. And then for the other aspect of practically reducing the burden of collection is to make sure really that you're just collecting those items, those documents and types of information that really are responsive to the claims and defenses in the case. Sometimes the request will come in to say, for example, we want all of the email from these 5 key salespeople in the organization. Well, I think some pushback could be, is that what you really need? Do we really need to collect all of their email, or is there a time limitation? Is there a date range that we can carve out and say only those things between January 1, 2009 and maybe March 15, 2010, if that's the relevant range of activity, and then only collect that smaller portion of information and of documents. So a clear understanding of the issues, the claims and defenses of the case, the time frame, the people involved, all of those will help you to be more targeted in your collection. And the other thing to keep in mind is if you've done preservation right, you can always go back and collect more if you need to. So it's where you can do that incrementally. You collect what you think is most relevant, and if the other side pushes back or you're ordered by the court to get something else, if you've preserved properly, you can always go back and get more if you need to.
Mm-hmm. Certainly everybody looks for a competitive edge, trying to understand what the other side has, trying to project what the other side has, what they don't have. And it seems like legal strategies certainly can be looked at like an arms race. And if an attorney knows that their opposition either has poor record keeping or may have a great overwhelming burden in producing discovery, how will they use either of those to their advantage?
Oh, that's a great question. And, on behalf of many business owners and many of the clients that we work with at our firm, I wish that there were a simple answer to this that somehow would level the playing field. But the reality is, often in litigation, there's one party who is larger, either in size or volume of information, and one that is markedly smaller, maybe an individual plaintiff or a very small group that might have very limited information, very limited data, and in that case looking at very limited discovery costs on the producing side. So there are a couple of strategies that business owners could utilize here. One is a philosophy of proportionality that's been championed by the Sedona Conference, which is an organization of litigators and thinkers in this area who have tried to not only articulate current best practices, but to work on formulating new best practices in some of these areas for reducing cost and increasing efficiency in litigation. But the notion of proportionality goes hand in hand with another notion, which is cost sharing. We'll talk about that in just a minute. But proportionality, and oftentimes the reality is you're going to need to have, the judge is going to have to give relief to a party in this area. And so you can make the argument to the court that says, look, the other side is requesting, the whole the whole barn full of information. What's really only relevant, this is not a big case. It's a disproportionate expense. Let's try to limit discovery. And more often, judges will be open to that. And when you link that with the notion of cost sharing, it sometimes can become a compelling argument. So, for example, you may have a case where the other side is asking for all of the documents and information from 25 or 30 individuals within the company. And you as the business owner says, look, there really are only 5 people who would have touched information that's related to the issues, the claims and defenses in the lawsuit. So you could go to the court and say, Judge, we'll produce these 5 custodians and data from these 5 custodians. If the other side wants more, we'll do that, but Judge, we want an order from you that will shift the cost of those additional custodians to the other side. And that can be an effective tool because it really makes the other side, if the judge goes along with your idea, it can make the other side say, well, how much do we really want these others? And it really can help to level the playing field because they're then going to have to bear some of the costs.
I see. It's definitely the way Joe titled the show, it's complicated, really seems to be right on target. I'm sure there are going to be many listeners that are going to be shaking their head and saying, oh, my God, what do I do? But, let's assume, Ken, for discussion's sake, that we have a franchisor and a franchisee who are both being sued by a customer, and that customer's attorney is requesting that the defending parties produce all kinds of information and a lot of the information that you touched on. How might the franchisor and franchisee process that request?
That's a great question, and so will we assume for the purposes of this question that the interests of the franchisor and franchisee are aligned in this litigation?
Yeah, let's assume that for this.
Okay. Well, for this, because in some ways it makes it a little simpler, if the interests are aligned and in essence what you have is a joint defense, then it makes sense for the franchisor and the franchisee to talk together and say, who has this information, who can get at it in a most cost-effective way, how can you present a united front in sort of pushing back and seeking to narrow the information requests? Certainly, both the franchisor and the franchisee would need to, a best practice would be each of them issue their own preservation notice or legal hold notice to their affected personnel. Each of them to produce so you've got that covers the preservation side. To look and to say, for collection, one of the things that the franchisee and franchisor could do in this way in terms of discussion is avoid duplication. So if one of the two parties, the franchisee or the franchisor, has a sort of a better repository or a more easily accessible repository, let's say it's some financial records have been requested, of the same set of documents, then it's worth it for them to talk about who does it make more sense as between the two of them to collect and review and produce. The other side is entitled to certain information, but not necessarily entitled to multiple exact copies of the same information. So from strictly a cost-saving perspective, the franchisor and franchisee could talk about what are the ways in which they can cooperate. And then what actually makes the best sense is if the plaintiff, an individual, has requested certain information, is really to have a discovery conference, what we call a meet and confer, with the other side. So you get the franchisor and the franchisee who go into this meet and confer together to talk with the individual plaintiff's attorney and say, you've asked for these 10 categories of information. the franchisor will produce these 5, and the franchisee will produce these 5. And if you can get agreement on that, you've really just cut the burden for both the franchisor and the franchisee in half, and also complied with the discovery requests. And depending on the situation, the franchisor and franchisee might look at it and say, you know what, it's really worthwhile taking this to the judge and saying, Judge, the requests from the plaintiff are duplicative. He's asking for the same information from both of us. We'd like relief from you, Judge, so that we only have to produce this essentially one copy. So there's some benefit in sort of talking with each other, coming up with a cooperative strategy. But I also think, and this really kind of cuts against some of the image that we have of litigation attorneys, but I really do believe that in some cases there can be benefit of, there actually can be true cooperation that ends up saving money for parties on both sides, and it certainly is worth exploring.
You know, Ken, it's interesting talking about document and discovery practices within the context that Paul laid out. But what is the process for review and coordination to determine what must be provided, which you've touched on a little bit, but also you've got two parties. You've got the franchisor and the franchisee, and assuming the franchisor is a mature franchisor with a lot of policies and procedures in place, but the franchisee is just a mom-and-pop business owner, how do you ensure that you're complying with the judge's or the court's prescriptions and you're not missing something, not because the mom-and-pop franchisee is trying to withhold stuff, they just don't know any better. How does that mechanism work?
Well, typically in that case, each of both the franchisor and the franchisee, each will be represented by their own attorney, and those attorneys bear a lot of that responsibility to make sure that their clients are complying with their legal obligations. You know, the probably the greatest risk, frankly, that arises in a situation like we're talking about is where two defendants may have access to the same documents, and the attorneys are reviewing and reach different conclusions about whether something is responsive to a discovery request or not. Now, in most cases, in the generally speaking, in the document review process, whether it's being done by your outside merits counsel, or if it's a very large case by some contract attorneys or somebody that your outside counsel has arranged with to do this document review in a more cost-effective way, typically there'll be the documents that you've collected will be broader than the documents that are actually relevant to or responsive to the discovery requests. So the typical way is an attorney or a team of attorneys review those documents. They sort of review the document on one side, and on the other hand, they're looking at the discovery request and saying, does this document that I'm looking at, an email, a spreadsheet, a Word document, a paper memorandum, does this relate to any of these specific document requests? And typically in this, there are a lot of documents that it's clear that they do relate. There's another set of documents that it's pretty clear that they're unrelated. And then there are those that are in sort of that gray area in the middle, and that's the one where you have the greatest risk of sort of inconsistency. I suppose if there's a joint defense agreement between the franchisor and the franchisee, one thing that could happen to avoid those inconsistencies is the franchisor and franchisee could pool the documents they've collected and have simply one set of reviewers. But generally, frankly, the understanding is in the gray areas, when two different people look at a document and could decide, sort of a close call, it could go either way, everybody expects that the process is not going to be perfect. everybody expects that there are going to be documents that ultimately are produced that are not really relevant, and everybody expects that there are going to be some documents that probably should have been produced that were missed, not on purpose as an effort to hide them, but just because somebody looked at it and didn't quite see it as responsive. The whole notion in litigation is, what is reasonable, what is appropriate and proportional for the case, and making best efforts is really what courts are going to look for litigants to do, is to make their best efforts to preserve, to collect, to review and produce the documents that are relevant to the issues in the case.
So you're saying it's probably a pretty poor idea for someone that gets sued to go out there and start to purge their email and delete all kinds of things because they think that they're going to be protecting themselves, and that's probably unwise.
It's probably, you could put unwise in all caps and underlined and bold with exclamation points, and that still wouldn't be strong enough. Because the reality is, in a piece of litigation, what has already happened has already happened. And the only thing that a party can do, that a business owner, the only thing that can happen if you try to sort of clean up the bad documents is make it worse for yourself. At some level, what's done is done, and no need to complicate things by, in a sense, adding insult to injury or injury to insult by getting sanctioned or an adverse inference instruction. Because what can sometimes happen is, if this bad behavior and certainly the intentional destruction of relevant information, the court frowns on that and is extremely displeased, and frankly the judge has a lot of leverage. The judge could sanction a party and say, you need to pay X amount of dollars to the other side, regardless of the outcome of the suit. The court could say to a jury, for example, could give an instruction to the jury that says there's been evidence in the case that the business owner has destroyed information that's related to the plaintiff's claims, and so you can assume, jury, that anything that was destroyed would be unfavorable to the business. And that kind of instruction is it's weighty, and it's really outweighs. I believe generally that kind of instruction and the tools that a judge has to enforce compliance with legal obligations really outweighs any possible benefit of getting rid of, quote, bad, unquote, documents.
Well, I think you just convinced everybody listening that they ought to have a really sound documents retention policy and really good procedures in place so that doesn't happen either intentionally or unintentionally. But on the whole idea of e-discovery and preparing for litigation, what does something like this cost? I mean, business owners, franchisors, franchisees, they want to know, geez, it sounds like it's a lot of stuff, but, they want to be able to say, and you can certainly use this example that Paul laid out of what something like this might look like in terms of preparing for the litigation. But generally speaking, what are the costs?
It's a great question, and there really are two or three different kinds of costs. There is the monetary cost, dollars out of pocket, and that's oftentimes significant. That's going to vary very dramatically, but it really is pegged to the amount of information that one of the parties to the litigation has. So the more documents and information you have, the more you have to preserve and collect and review, the more it's going to cost. There's also, sort of a less obvious cost is there is a business disruption cost to litigation. People are taken out of what they're doing for their business because apart from litigation law firms, it's nobody's business to be in litigation. For our listeners today, they're franchisors, franchisees, they're in the business of operating businesses, not in the business of litigation. So anything that takes people away in their attention, in their time, from running the business, there's a cost there. But for the business owner, there's also the person who is sort of feels the weight of being sued. There is also a cost there, a certain emotional and distraction cost to that as well. So while it's difficult without knowing the volume of documents to put a dollar cost, the dollars is just one cost. And these really have to go in and factor in early in a business owner's consideration of what is this case worth? What is it worth either to pursue or to defend? And it's for those who just want to stand and say, you know, this is wrong, and no matter what it costs me, I'm going to defend against this. That's the business owner's decision to make. But man, count the cost before you sign up for that, because it could be substantial, and it might be sort of the better part of discretion to say, from a strictly economic standpoint and from a business disruption standpoint, I could write a check for, you know, $50,000 and be done with this, or I can go through this protracted litigation and it's going to cost me $100,000 to get through discovery and the business disruption. And business owners really need to weigh that and weigh all of those areas of cost in deciding early on how aggressively do we want to defend, or do we want to seek a resolution of this lawsuit outside of a trial.
Well, you know, certainly, Ken, listening to all this, and I know a lot of our listeners will feel the same way. I think one word describes all this, which is wow. You know, listening to the different things that you're saying, I could see the necessity from a legal standpoint in having a social media and digital forensics expert, if you would, trying to find some of all the information that might be out there, which leads me to, you know, when your partner, Jonathan Redgrave, was a guest on Franchise Today, we were kind of taken by surprise when he mentioned that the Library of Congress was archiving every tweet on Twitter. And you're in the thick of things where lawsuits and evolving technologies converge. So what's the next big surprise in information law and e-discovery that you could leave us with as we are closing down the stretch of today's segment?
You know, I think the next big thing, and it's gotten a lot of it is the hot item really right now in the whole e-discovery discussion, is computer-assisted or technology-assisted either document review or within the records and information management kind of world, information governance, what's sometimes called auto-classification. And the emerging technologies, and this is still a pretty new area, but I think in the next 6 to 12 months we're going to see some dramatic changes here where computers are trained through some complicated algorithms, and you know there's a reason I'm a lawyer and not a mathematician, and so it's well beyond me, but to identify based on a subset of known documents, they can extrapolate what's true about those documents, say what type of a document. The computer can be trained, for example, to recognize what a contract looks like, and then can search out throughout the entire enterprise and automatically classify different documents as, well, this looks like a contract, so we'll apply this classification. It can also happen in the document review space to say, you know, we've got these 500 documents that we know are relevant to the case, and the computer can be trained to go out into the universe of documents that have been preserved and collected and say, find other documents that are relevant. I think computer-assisted, technology-assisted review and classification is probably the next big thing in information law and e-discovery.
Wow. Great information, Ken. Thanks for being our guest today. We're running out of time, and certainly we could have you back on in the future, probably 3 or 4 more shows. Really, thank you for being our guest today.
My pleasure. Thanks very much. It's been great to be with you and with the audience.
Next week we have Michael Webster as our guest in our sixth segment of the Franchise Legal Series. Until next week, my name is Paul Segreto, wishing you the best, the very best, in this great thing we call franchising. Franchise Today is out.
When you're part of a military family, you understand sacrifice and support. At American Public University, we honor your dedication by extending our military tuition savings to your extended family. Parents, spouses, legal partners, siblings, and dependents all qualify for APU's preferred military rate of just $250 per credit hour for undergraduate and master's level programs. American Public University. Value for the whole family. Learn more at apu.apus.edu/military.